Hi, I know this is a really difficult time for a lot of businesses right now, and a lot of you have questions about all of this new legislation and how it might affect you. And as a human resources consultant, I've been receiving tons of questions from my clients. And so for the next several days, I'm just going to be responding to some of those questions that I've received. And this is going to be covering the Families First Coronavirus Response Act, the CARES Act, and also some HR questions in general about some things that you should be considering and doing with your employees during this pandemic. So first, I'm going to introduce myself. For those of you who don't know me, my name is Cindy Kiner. I own the HR Connection, and I help small to medium-sized businesses and startups with their human resources and training needs. So let's get started. The first question: what is the Families First Coronavirus Response Act? The FFCRA is the acronym, and does it apply to my business? Okay, so this may be the only question I get to today because it is a very long answer. So the FFCRA is phase 2 of the stimulus packages that were signed into law because of COVID-19. This applies to employers with fewer than 500 employees. There are two major parts to this law. There is an emergency family and medical leave expansion and emergency sick leave. So under the emergency family and medical leave provision, employees who've been employed for at least 30 days are eligible to take up to 12 weeks of job protected leave if they are unable to work or telework due to having to care for the employee's child, or if the child's school or child care facility is closed or their care provider is unavailable due to a public health emergency. Okay, so under this, the first 2 weeks are unpaid, but the employee may choose to use some other kind of leave that's available to them through your regular policy, such as vacation and PTO. Weeks 3 through 10 are paid at 2/3 the employee's regular rate of pay for the regular hours they would work. Now, if you have part-time employees who work variable hours, you'll go back 6 months and average it out over the past 6 months, and that's what you will owe them, 2/3 of that. Employers with between 25 and 500 employees must return employees to work per the normal FMLA rules, which is it has to be the same or equivalent job with same pay, same status, and so forth. Employers with fewer than 25 employees who are exempt from this requirement if the job no longer exists because of the economic turndown. But they must continue to try to return the employee to employment for at least 1 year following the leave. So it's important to remember that under this expanded family and medical leave, the only reason that this leave needs to be paid is because of child care provisions, because of a school closure or the unavailability of child care due to COVID-19. Okay, the other part of the act is the emergency paid sick leave provision. There's no minimum length of employment, so if someone's been employed for 1 day, they are eligible for this. Full-time employees must be provided with 80 hours for the paid sick leave for any of the qualifying reasons I'm going to give you in a minute. And part-time employees must be paid based on the average of hours during the previous 6 months. Okay, so this is 2 weeks, equivalent to 2 weeks of pay. All right, so these are the reasons. Employees are entitled to sick leave for these reasons at their regular rate of pay: a federal, state, or local quarantine or isolation order related to COVID-19. If they are advised by their healthcare provider to self-quarantine because of COVID-19 concerns. Okay, this doesn't mean necessarily that they have COVID-19. It may mean that they are high risk and their healthcare provider has told them they need to self-quarantine. If they are experiencing COVID-19 symptoms and are seeking a medical diagnosis. All right, this leave is capped at $500 per day per employee. Okay, so you will not have to pay out more than $511 per day per employee if you have an employee who makes more than that. And this is only for 2 weeks. All right, employees are entitled to sick leave for these following reasons at 2/3 their regular rate of pay. If they're caring for an individual who is subject to a federal, state, or local quarantine or isolation order, or ordered to self-quarantined related to COVID-19 concerns. If they're caring for their child, if their school or facility, childcare facility is closed related to COVID-19. Or another thing that they put in there is if they are experiencing any other similar conditions specified by the Secretary of Health and Human Services, the Secretary of the Treasury, and Secretary of Labor. We don't really know what that means right now, but they put that in there. There's guidance coming out every day from the Department of Labor about this, so they're helping us little by little to know how to navigate all of this. So this leave is capped at $200 per day per employee. All right, so that sounds like a lot of money. If you and this could mean that an employee could be sick for 2 weeks, and you have to pay them, and then and then also if their child's school is out, you would have to pay them for weeks 3 through 10. So they could end up actually getting 12 weeks of pay. The first 2 weeks would be at full pay. The last 2 weeks, or the last 10 weeks, then would be at 2/3. Or it could be that they're getting those first 2 weeks sick leave for caring for their child at 2/3, and weeks 3 through 10 under the Family and Medical Leave Act. So that's a lot of money. So the next question that I have had is, how can I afford to pay this leave to my employees? I had one client that just called me up and said, should I just file for bankruptcy now? And it sounds like a lot of money. My business is already suffering because of COVID-19. So I will assure you that employers are going to be able to recoup 100% of this money that they pay employees through a payroll tax credit. And this will be claimed against taxes that you pay when you pay your quarterly 941. If the amount that you pay out to employees exceeds the amount on your 941, then you can claim a direct credit by filing IRS Form 7200. And then the IRS will send you a check to pay for to pay that gap. Okay, so the next question that I have is, well, back on that previous question, there's still more guidance coming out on that. There was some talk of possibly being able to claim against your payroll taxes that you pay, against all your taxes that you have to pay in. So we'll see if there's more that comes out about that. But at this point, that's how you recoup that money. The next question. I heard that there's a possible exemption for employers with fewer than 50 employees. Is this true, and how can I claim it? So the answer to that is yes, this is true for a portion of the FFCRA. But this is already a long video. That question is going to take a few minutes to answer, so I'm going to respond to that question tomorrow in another FAQ. So thank you so much for watching, and feel free to share this video. Come back tomorrow for more answers to your questions. If you need an answer to something right away, I'm going to put my contact information in the comments below. Feel free to ask me more questions in the comments or contact me directly. Thank you.